Good afternoon, everybody. We're live. Just waiting for everybody to log in to the webinar. We've got a lot of people still climbing on. How's everyone's day going? I'm based in Sydney. My name is Annette, and I work in the marketing team with HR Assured. Maybe you could tell me how you're going in the chat. Awesome. Who's working from home, or are you location based? Working from home. I'm also working from home today, but I have been going to the office occasionally. Oh, I see Samira. Hi, Samira. Awesome. Alrighty. We've got a nice amount of people here, so I think we should kick off. Awesome. Okay, if you missed it, my name's Annette. I work in the marketing team at HR Assured, and I'd like to thank you for coming along to our webinar today, addressing sexual harassment in the workplace. For those of you who aren't familiar with HR Assured, I'll just let you know a little bit about us. We help businesses navigate around Australia and New Zealand's complex employment laws by providing a range of services and products to ensure businesses are compliant. So as you can see on the screen there, when you do partner with HR Assured, you'll have access to our award-winning services, including a WHS audit, WHS management software, HR audit, HR software, our 24/7 telephone advisory service, insurance and representation, and a library of legal resources. So if I'll go to the next slide there, we're really excited to tell you that we've actually recently launched our end-to-end WHS solution. So if you are interested in talking to us about our solution, we would love to offer you a WHS health check, and you can get in touch with us after the webinar. We'll send you through some details in an email after this. If we can go to the next slide, I wanted to introduce you to our speaker today, National Workplace Relations Manager, Wes O'Donnell. Hi, Wes. Wes is a solicitor and he specialises in workplace relations. He has over approximately 20 years of experience, so a lot of experience. I'm going to hand over to you, Wes. But before we do, if you do have questions throughout this presentation, please make sure that you pop them in the Q&A section down the bottom here, and we will get to them at the end of the webinar. And yes, I can see somebody asking, will you see this recording afterwards? Yes, we will send it to you after the webinar. So if you do happen to need to leave or anything like that, we can get you a recording. Hello, Wes.
Annette, hi team, how is everyone? Thank you very much for joining me during your lunch hour. Really appreciate you joining these sessions, and thank you, Annette, for making me feel really, really old by saying 20 years then as well. That's really great. No worries. So as Annette mentioned, we're going to be having a chat today around some recent amendments to the topic of sexual harassment in the workplace. A lot of you may be aware that there's been some significant developments in this area since the production of a Respect at Work report in 2020 and recent legislative amendments earlier this year. We're going to go through all of that in a bit of a high level, but I want to concentrate mainly on some tips and recommendations that I am recommending to my clients that they should be putting in place in response to those amendments, and also the expansion of the jurisdiction of the Fair Work Commission to now hear complaints relating to sexual harassment. So we will go through the legislative framework and the changes and a little bit of detail around the Respect at Work report, but predominantly focusing on the practical tips and suggestions. As Annette mentioned, we don't like to operate a lecture style approach in these types of events. It is more of a facilitated workshop with our valued clients. So if any of you do have any questions as you go through, please feel free to raise them within the Q&A function. Where I can, I'll try to note them as I go and respond to them if I can, but if not, we intend to leave lots of time at the end to address people's questions. So please don't feel abashed in raising any questions as we go through. So as mentioned, we're going to briefly talk about sexual harassment, as a global issue, also focusing, of course, on the Australian experience as reflected within the Respect at Work report. We're going to update you on the changes to the legislative framework predominantly arising from that report and review, which was tabled in 2020. I'm predominantly going to be focusing on some tips and recommendations that I'm discussing with clients around how they could perhaps be more effective in addressing sexual harassment in the workplace and also implementing internal structures to maximize your prospect of success in responding to these type of issues if and when they arise. One of the important areas that I am recommending that clients consider is the use of alternative dispute resolution procedures as a means to address sexual harassment allegations in the workplace. And in particular, by that I mean workplace mediation, which I think is an effective tool for businesses to consider. So we'll be going through not only the tips and recommendations for your internal framework, but also some overview of what the benefit of workplace mediation as a possible approach to address these type of issues. And of course, as mentioned, we'll leave as much time as I can to address the questions at the end. But of course, as valued clients, if any of you do have questions that can't be addressed in this session or we don't have time, please make use of the telephone advisory service. My colleagues are more than happy to help you out in any question that you may have. So that being said, sexual harassment. As we all know, the topic of sexual harassment has probably increased as a discussion point arising from the Me Too movement. That Me Too movement has not been restricted to Australia, but has really been a force throughout the world and has really had a great deal of benefit, I think, in localizing the discussion around an person's expectation to be treated with courtesy and respect in the workplace on all occasions. And I think that that conversation, although it's been very difficult for many to have, I like to think has really driven some improvements in the workplace in the short period that we've been focusing upon this. Personally, I think that we've still got a long way to go to address some of the underlying issues and respond to sexual harassment allegations in a more effective manner. But I have been personally pretty pleased with some of the initiatives that clients have undertaken to respond to these type of issues and the consideration that has been given to the particular topic. So against that background, there has been, as I've mentioned, a number of discussions around the topic of sexual harassment in the workplace, the underlying causes of that in the workplace context and how we can be more effective in addressing allegations of serious sexual harassment. It's probably important to note, though, that sexual harassment and the legislative framework in which we're operating in Australia is pretty crowded already. And as the diagram illustrates, legislation of some description concerning the sexual harassment has been in place for around 50 years. It started with Australia ratifying an international convention on discrimination in employment in the early 70s, and then progressed through to various states, starting with South Australia, closely followed by New South Wales and Victoria, introducing their own legislation which effectively addressed sexual discrimination in the workplace context. In '84 was the first federal act which addressed the issue of sexual harassment, and then we've progressed through in changing that both from a legislative perspective, but also the tribunals and forums in which it's addressed over time. And that's been, 1992 as an example, the Sex Discrimination Act was varied. to remove the requirement for the complainant to demonstrate actual damage in the course of their employment as a condition and precondition of being successful in raising a complaint, through to recent amendments which are based on a 2018 national survey of harassment in Australian workplaces, and also the Respect at Work report, which was released in 2020. For those who haven't had the opportunity to review the Respect at Work report, I would strongly encourage you to do it. The entire report of itself is a pretty voluminous document to read, but it is publicly available on the Australian Human Rights Commission. There is a pretty comprehensive but also really useful executive summary, but it does make for really interesting reading, and from my perspective has been really insightful to better understand the prevalence of sexual harassment in the workplace, but also the manner in which it arises. From that report, I just wanted to give you a few statistics and which I was quite surprised around the prevalence of sexual harassment in the workplace. But the report largely draws on a 2018 national survey upon workplace sexual harassment, and it notes that 33% of people in the workplace who have participated in the workplace in the last 5 years had actually experienced sexual harassment. So that's, of people that have been participating in the workplace at some stage in the last 5 years, 33% of them have indicated that they're being sexually harassed. And that figure is higher for women at 39% versus 26% for men, as you would expect. But 1/3 of people experiencing sexual harassment is a really significant number. That survey went into further analysis around the forms and the nature of that harassment. And as we would probably and have anticipated, the most common forms of harassment include, sexually suggestive comments or jokes, as well as intrusive comments about a person's life or appearance. The report also went into further particulars around in persons who are harassing other individuals. Typically have responded by stating that they were not aware that their comments were considered inappropriate or intrusive in any way. And when I discuss this with clients, I think that's really key because we all come to the workplace with our own personal views and personal experiences, lived experiences, etc. And an individual's perception of what is appropriate, funny, rude, etc., is drawn from those personal views and personal lived experiences. But what's important in the context of sexual harassment in the workplace is not what an individual's perspective of appropriate workplace conduct is, but rather it's really important that they gain a fundamental understanding of what the company's values are and what the company's perspective of appropriate workplace behaviour is. Meaning that when they come to work, they leave their personal views at the door and they come into the workplace complying with the company's values and expectations of mutual respect and courtesy. The survey also indicated that of those who had been harassed, 45% of them had been harassed for over a 12-month period. So that's of itself quite significant because it indicates that those people who have been harassed over an extended period of time. The report goes on further to say that those who are more likely to be subject of sexual harassment in the workplace are young workers, being those aged under 30, those within the LGBTQI community, persons with disabilities, Aboriginal workers or those from migrant backgrounds, and individuals within insecure work, as it's described, labour hire, casual employment relationships, precarious working arrangements, etc. So we can already see that those who are experiencing harassment in the workplace are more likely to be vulnerable, for want of a better description, in that they're aged, as impacting their personal experience, background, etc. And even though the report outlines this, I think it's probably fairly well understood that sexual harassment has a really significant impact upon not only an individual's well-being, their personal financial security, but also has significant impacts on the workplace in the form of lost productivity, staff turnover, reputational damage, and negative impact on workplace culture. So even though there's an individual impact which would certainly suggest that there is a need to address this in the workplace, there is also a significant impact upon the company, which would certainly warrant further attention to this particular issue. And if we look at reputational damage, it only takes a brief Google search of some of Australia's largest organisations to see that allegations of sexual harassment, which has been addressed well over 5-10 years ago, still continue to plague those organisations. So certainly the issues arising both from an individual perspective, but also from an organisational perspective as well. Now, I want to briefly, before we go into the changes which has arisen from the Respect at Work report, just want to briefly remind people of the previous definition of sexual harassment, which was that a person sexually harasses another if the person makes unwelcome sexual advances or an unwelcome request for sexual favours to the person, or engages in unwelcome conduct of a sexual nature, which is likely to offend, humiliate, or intimidate. So again, critical issues here is unwelcome conduct of a sexual nature, which is likely to offend, humiliate, or intimidate. That being said, the Respect at Work report indicated that the prevalence of sexual harassment in the workplace and the impact upon it results in a need for significant amendments in the Australian legislative framework. And predominantly the recommendations of the report suggested simplifying and strengthening the legal framework to increase existing rights and obligations upon both employees and employers, improve alignment between agencies and legislation, and with that has resulted in amendments to the Australian Human Rights Commission and the jurisdiction of the Fair Work Commission, which we'll discuss in a moment. To effect those changes and the recommendations of the report, the report findings were implemented through changes to the Sex Discrimination Act, as well as I mentioned, the Human Rights Commission itself and the jurisdiction of the Fair Work Commission as reflected in the Human Rights Commission Act and the Fair Work Act, which we'll go through each in turn. So we've discussed the previous definition of sexual harassment in the workplace, and the new definition is outlined on the screen now. So in a couple of important points which we'll go through, but for the purposes of the Act, a person harasses another on the ground of sex if, by reason of the sex of the person, they are harassed, a characteristic that appertains generally to persons of that sex is harassed, or a characteristic that is generally imputed to the person's sex is harassed. So it provides already a much broader definition. So it includes not only the sex of the individual, but a characteristic of the individual that may pertain to their sex. This may be something generally like, a doctor given pink scrub, male doctor given pink scrubs rather than blue, as an example, or a characteristic that is imputed because of the person's sex. And this might be inappropriate comments around, a woman's place being at home or something of that nature. So it broadens it out to ensure that it's not necessarily just the sex, but characteristics pertaining to or imputed to relate to that particular sex or characteristic as well. The other difference is that you remember how we've said previously, the previous definition was unwelcome conduct of a sexual nature. The definition is now different in that the person engages in sexual harassment if they engage in unwelcome conduct of a seriously demeaning nature in relation to the person harassed. So we can see, significantly different. So we're changing from unwelcome conduct of a sexual nature into unwelcome conduct of a seriously demeaning nature in relation to the person harassed. And of course, that test, that reasonable person test, remains in that, and there is a requirement that the person does so in circumstances in which a reasonable person is likely to be offended, humiliated, or intimidated. Now, I personally think that this revised definition broadens the field and potentially captures much more conduct within the workplace, and therefore there's many more circumstances which are likely to meet the test of sexual harassment in the workplace. But it's not likely to capture those low-level type issues which are not likely to offend, humiliate, or intimidate. So it's an increased threshold or broadening of the scope, but still that reasonable person test remains, which effectively means that low-level conduct, which is not reasonably likely to offend, humiliate, or intimidated, won't be captured within the provisions. Another significant change which the legislation has put in place is to alter the jurisdiction of both the Human Rights Commission, which is the commission which predominantly deals with complaints arising from the Sex Discrimination Act, as well as the Fair Work Commission. Now, in relation to the Human Rights Commission, I don't really want to go into a lot of the detail in terms of some of the amendments that have been made. But perhaps one of the most significant, and from a practical perspective, is that the changes to the legislation has significantly amended the discretionary grounds upon which a complaint may be terminated by the President of the Australian Human Rights Commission. And prior to the change, the President of the Australian Human Rights Commission was required to effectively undertake a preliminary assessment of all sexual harassment complaints received, and had a broad discretion to terminate a complaint, or in another term, dismiss a complaint, where a complaint was made 6 months after the alleged unlawful conduct took place. Now, I think appropriately, the changes which have been impacted, or implemented rather, as a result of this report has altered that period from 6 to 24 months. Yeah. So now that discretion applies, but only applies where the complaint has been made 2 years after the alleged unlawful conduct. And I think this really aligns with the significant power imbalance sometimes which is inherent within sexual harassment, but also the difficult personal circumstances that a complainant often experiences as a result of these type of workplace behaviours. So I think that extension of the period in which an individual can make a claim without risk of the President exercising the right to terminate the complaint is a significant one. Whether it results in an increased number of complaints is yet to be seen, but it will avoid a possible ground upon which complaints can be terminated at an early stage. The other significant change, and predominantly the reason why we wanted to undertake this session today, is the amendment made to the Fair Work Act to broaden the jurisdiction of the Fair Work Commission to hear complaints of alleged sexual harassment. Now, this jurisdiction effectively came into place on the 11th of this month, meaning that persons can now raise complaints directly with the Fair Work Commission, asserting that they have been harassed in the workplace. Now, what the amendments have done is that they have broadened the existing anti-bullying jurisdiction, which was introduced in around 2016, which permits an employee to directly complain to the Fair Work Commission, asserting that they have been bullied in the workplace. That application seeks the interjection of the Fair Work Commission, who, if satisfied that bullying has taken place, has broad powers to make any orders that it sees fit, with the exception of monetary compensation, to ensure that bullying no longer takes place. Now, we haven't necessarily seen the flood of applications that we were otherwise expected in the anti-bullying jurisdiction. I believe from memory, the most recent Fair Work Commission report indicated that in the last year there was less than 1,000 claims received, which is certainly a lot less than the 15,000 unfair dismissal claims and approximately 8,000 general protections applications. But predominantly we're seeing that the reason for that is suggested to be associated with the inability of the Fair Work Commission to award monetary compensation. We have seen, however, that the Fair Work Commission deals with these types of matters incredibly quickly. When the jurisdiction first came in, we were receiving directions to attend the commission the very next day. Slow down a little bit, but there is a direct obligation upon the Fair Work Commission to deal with these types of issues without undue delay. So we will receive notification pretty quickly. Now, what this change has done is indicated that the Fair Work Commission can now hear these types of complaints in relation to both bullying or allegations of bullying, as well as allegations of sexual harassment in the workplace. Now, what impact does this have? I think that actually is quite a significant change. It does provide a pathway for employees to raise a complaint without first utilising internal grievance or dispute procedures within the organisation, meaning that an employee can raise a bullying allegation or a sexual harassment allegation without first having to raise a complaint with the company or allowing the company an opportunity to, at first instance, consider it. We do find as well that that of itself creates a pretty significant risk to not only the organisation's reputation, but also the professional reputation of the alleged harasser or the respondent to proceedings. So the likely impact upon such a complaint is certainly significant, both from the organisation's perspective and the individual respondent involved. Now, we'll get into it in a little bit, but I wanted to talk through just briefly around the process. And this will lead into discussions that we'll have in relation to means by which you can address sexual harassment successfully in the workplace. Through the bullying jurisdiction, we have typically found that the Fair Work Commission will list matters quite quickly, meaning that they'll commence that process of considering the complaint, within a couple of days, if not a week. One of the first steps in that process is an initial mention and directions hearing where the parties come together before a member of the commission to consider at first instance the complaint which has been received, the allegations contained within it, but also the way in which the Fair Work Commission will deal with that type of matter. Now, in our experience, having dealt with many applications in that anti-bullying jurisdiction, where there is no framework within an existing organisation around values, policies, expectations, training, etc., it's sometimes difficult to convince the Fair Work Commission to allow the company an opportunity to address the allegations internally at first instance. And in some cases, the Fair Work Commission, expresses a view that if you've not got such a framework, they lack the confidence that the organisation will be able to deal with it effectively. Having said that, where we've gone into these initial processes with the Fair Work Commission, representing clients, employers, and are able to demonstrate to the Fair Work Commission that the organisation has very established corporate values which promote equal opportunity and acceptance within the workplace, where the organisation has entrenched policies, procedures, complaints and grievance mechanisms, where the company has structured contracts of employment specifying expectations concerning bullying, harassment, discrimination in the workplace, where the organisation has an established grievance mechanism to enable these matters and allegations to be dealt with effectively. We're finding that the Fair Work Commission is more likely than not going to agree to an application to be stood over generally for a 1 month, 2 month period to enable the organisation to address the allegations internally in line with its grievance procedures. I think that's quite significant because we are seeing that the anti-bullying and now the sexual harassment jurisdiction does present, as I mentioned, a quite significant organisational, personal, reputational threat. And one of the ways in which we can successfully counter that is by having very established internal processes, procedures, which may, if a complaint is raised with the Fair Work Commission, enable you to convince the Fair Work Commission to internalise that process to address the conduct. But of course, if the employee is unhappy at any stage, they have the right to go back to the Commission and go through the formal process. So we're now, having understood the framework and the changes and the increased jurisdiction of the Fair Work Commission, we want to go through a couple of tips from a practical perspective around how we can be more successful in addressing sexual harassment in the workplace, predominantly from an existing WHS perspective, given that we have a primary duty to create a safe place of work, identify hazards including bullying, harassment, etc., and implement appropriate control measures to avoid conduct of that type to the extent that we can. So first thing is creating a safe physical and online working environment. That obviously extends to technology and IT platforms, and the report which I referred to earlier does indicate a very significant prevalence of sexual harassment using technology or IT. We need to consider safe systems of work and procedures naturally, meaning that we need to have established policies concerning bullying, harassment, sexual harassment in the workplace, but also an established process by which complaints or grievances around sexual harassment can be addressed. We need to create a respectful workplace, and by that we mean creating a culture which is reflected in everything that we do, and we live by that. Some of the best clients that we deal with, have really strong workplace cultures, and all of their people decisions are driven by that culture and their values, which makes it very easy to respond to really significant issues such as bullying and sexual harassment when they arise. Implement obviously policies, but we would also recommend that there be an amendment or inclusion within contracts of employment which do specify base level expectations of bullying, harassment, equal opportunity, diversity, etc., and also indicate that any conduct in breach of those expectations will be viewed as serious misconduct, which may result in disciplinary procedures and termination. That of itself, both the framework and the contract, is a really important step for organisations to get right. And it's important given that organisations are generally liable for the conduct of their employees within the workplace as it relates to sexual harassment, except to the extent that the company has taken all reasonable steps and measures to avoid conduct of that type. Yeah. So what we mean by that as well is not only do we need to implement these steps from a WHS perspective to minimize harm within the workplace, but it's also a fundamental requirement, in my view, to enable you to more effectively respond to complaints within the Fair Work Commission should they arise, but also to respond to any formal complaint within the Australian Human Rights Commission and subsequently the Federal Court. And of course, that deals with regular training, addressing unwanted or offensive behaviour early, addressing unwanted or offensive behaviour consistently in accordance with your culture. Yeah, don't make exceptions because of the nature of the employee or the relative importance to the organisation, and be timely and consistent in the way in which you're dealing with those complaints. A few other tips that we're finding is that often complaints are dealt with poorly from an organisational perspective, and commonly this is a reflection of their lack of dedicated internal HR resources, and they may either not address it or address it in a very poor fashion, which leads to either an incorrect or a biased outcome. Now, without wanting to go into detail around what is a proper workplace investigation process or how we should address it, because they're matters that we'll deal with and assist and support you through the telephone advisory service, it is important to note that a poor investigation will significantly increase your risk of litigation and dispute, likely to result in workers' compensation outcomes, given that an employee will likely allege that they're experiencing some form of psychological injury arising from unreasonable workplace practices, as well as the company's failure to investigate the matter appropriately. Will likely result in significant brand damage, and we can see a number of very large companies, you need to Google them, I won't mention them by name, who have addressed allegations of sexual harassment poorly and have still experiencing the damage to their brand and reputation as a result. And of course, it creates negative perceptions within the organisation, which impacts on employee engagement and culture as well. So I would strongly encourage you, whenever you do receive an allegation of sexual harassment, however serious, and regardless of whether the complainant indicates that they don't wish to raise the matter formally or don't wish to deal with the matter in a formal sense, I'd strongly encourage you to ring through to the telephone advisory service so that we can give you advice on how we can assist you in addressing that allegation effectively, so that we can avoid somewhat small issues occasionally becoming large complaints and leading to disputes. One of the things I would like to really promote is alternative dispute resolutions as a means of effectively addressing sexual harassment complaints within the workplace. Now, one of the reasons why I suggest this is that often investigating allegations of sexual harassment in the workplace is very time intensive. Yeah. And if we outsource, there's a pretty significant cost contribution as well to get that right. But from a more basic and fundamental perspective, I always say that with an investigation relating to sexual harassment, there's often no winners. Yeah? And what I mean by that is, if an investigation is undertaken and the complaint is not substantiated because it doesn't meet the legal test or the threshold test, etc., or there's a lack of corroborating evidence to support the allegation, inevitably the complainant will feel significantly aggrieved by the process, not feel supported, not feel protected in the workplace, and will likely continue the dispute in some form. Could resign, but more likely, bring a workers' comp claim, constructive unfair dismissal, sexual harassment claim, etc. And it may be that's a proper approach. Conversely, where you undertake an investigation and the allegations are either partially or completely established or substantiated, inevitably the respondent will disagree with the findings and believe that the process has been flawed or unfair or biased in some description. So regardless of the outcome, it's likely to be inevitable that one of the parties or both will be dissatisfied with the process or the outcomes to that procedure. And that of itself may prevent the organisation from supporting the individuals in returning to a safe and productive workplace where possible, which is ultimately the goal of the process. So that being said, one of the options available to organisations, which I'm raising in conversations with clients, is the option of introducing workplace mediation as an option of addressing the conflict situation or the complaint. Mediation of itself is suitable for most circumstances, subject to the parties voluntarily participating in the process and feeling confident and safe in doing so, which is something that the mediators will work through. And it's really effective in either avoiding legal proceedings or significantly reducing the incidence of legal proceedings. Now, of course, I completely acknowledge that not all circumstances of dispute or sexual harassment are appropriate to be addressed by way of a mediation process. Completely acknowledge that, and we certainly acknowledge that both bullying, harassment, and other forms of workplace conduct experienced ranges in seriousness and its impact. So by all means, we would be happy to explore, and the workplace mediation experts, which I did work with in FCB Group, would be more than happy to explore the circumstances and whether a mediation is appropriate in the circumstances. And of course, it needs to be voluntary. And what we mean by that is where parties come into a mediation process voluntarily, they view the outcome as their outcome, as opposed to an outcome which is imposed upon them by the organisation. And where parties voluntarily participate in the process, as mentioned, they are likely to perceive the outcome as their outcome and are therefore more likely to comply with the terms of that agreement or outcome over a longer period of time. So a few more details about mediation and why I think it's going to be a possible avenue for you to deal with sexual harassment in the workplace. Firstly, mediation of itself assists the parties in identifying a solution to their dispute. So it's not the organisation imposing an outcome, which is what the investigation process entails, but rather it's a process by which we assist, or the mediator assists, the parties to identify their own solution to the dispute. That process does not involve apportionment of fault or blame. It moves past fault, it moves past blame, and focus upon the outcome. So what parties need to achieve or experience in order to move on and to experience or enjoy a safe, productive working environment. Although an acknowledgement of hurt or fault in some way may form part of the mediation process, it's not the focus, which is the focus of the investigation procedure. The focus is moving past that fault, blame, or acknowledgement and moving to a position which focuses upon active solutions to provide parties what they need to maintain or achieve a successful, productive, and safe working environment. Now, that of itself will lead to a repairing, hopefully, of the relationship between the parties, or at least the establishment of a professional relationship absent any ongoing sexual harassment. It also enables you to pull apart issues in future, and a successful mediation process will provide the parties with the resources and skills needed to effectively raise issues locally and personally where they go off track or where some unreasonable or unexpected or unprofessional rather behaviour occurs. Yeah. It will also result in an understanding of the other party's needs. It will also result in a reduction in the amount of managerial time needed to achieve that type of outcome and manage it moving forward. So we're not suggesting at all that there is a need to go down the path of workplace mediation in all circumstances. We do certainly recommend that it is an option which should be explored when we're considering ways in which we can approach it. And we've got a couple of really great experts within FCB Group in my colleagues Nicole Vecito and Amanda Katori, who would be happy to explain the workplace mediation process and the benefits which it can deliver to your organisation, but also those parties involved in the dispute. So hopefully we can see then that there has been some, I think, quite significant changes to the legislation. I would strongly encourage everyone on this call to take a number of active steps if you haven't already done so. The first is, I think, that everyone needs to revise excuse me, their equal opportunity and diversity policies to ensure that they're up to date and current with the new legislation. I'd also strongly suggest that for any company on this call that does not have robust procedures and grievance mechanisms to review the policy framework within HRA Cloud, or contact the telephone advisory service, and we'll be more than happy to support you in implementing that complaint mechanism and grievance procedure. For organisations that do not have these base level expectations within an individual's contract of employment, we would also be strongly recommending that you do so. And we would be suggesting that it be implemented as a fundamental requirement of their employment, that they not bully, harass, sexually harass any individual, which may be viewed as serious misconduct. We'd also strongly recommend that organisations undertake effective training and development upon bullying, harassment, sexual harassment. That should be an ongoing process as part of your overarching WHS considerations, where we're required to identify hazards and put in place training and other control mechanisms to minimise those type of hazards within the workplace. If you haven't already done so, we would suggest that you implement that training. If you have already done training in the past, the recent amendments to the Fair Work Act, as well as the Sex Discrimination Act, we think that it's timely that you consider those types of training sessions again. For HRA clients, we'll be looking to schedule some of those training sessions on a complementary basis throughout the new year. We'd also recommend that for those that are responsible for investigating or considering or responding to sexual harassment allegations in the workplace, we would strongly recommend that you consider the recommendations in this presentation, strongly recommend that you reach out to the telephone advisory service, and also put in place an appropriate investigation procedure, or consider workplace mediation as an option or as an alternative to addressing that conduct in the workplace. That being said, we do appreciate that there's a lot of action items arising from this presentation. And we appreciate that it's a busy period of the year when we're needing to implement all these. And we would be encouraging all of our HRA clients to contact us so that we can support you in addressing those recommendations over your forward life cycle, your HR life cycle. We're not needing to get it all done tomorrow, but we really should be considering all of the recommendations that we've provided in today's presentation and making sure that over your forward HR cycle, we've set aside enough time to address all of those particular recommendations. For those of you who are not HRA clients, and I think there's a few of you, or for those of you who are considering our new WHS product, we would be more than happy to arrange a complimentary consultation with you. If you scan the QR code on the screen, a copy of this presentation is also going to be available on our website or after. That will lead you through a landing page where you can simply provide your contact details, and one of my colleagues will give you a call to address either your internal HR issues or to discuss how we can support in our WHS product. That being said, promise to leave enough time to answer a few questions. So we do have a few. Please, if you have any questions arising from the presentation, please feel free to put them into the Q&A chat function now. But we do have a couple of questions, which hopefully we'll have enough time to get through as many of them as we can. So the first question is, if something happens outside of the workplace between employees, such as on an employee's private Facebook, how much responsibility does the employer have to address it? Yeah, really good question. It's really interesting. I keep going back to this report. And for those of you who haven't read it, again, I'd really encourage you to read it, or at least the executive summary when you can, because I found it really insightful. But one of the things that the report talks about, which is really, just it resonated with me, is that when we look at the development of sexual harassment legislation over time, from the early 70s, when we were the first signatory to the International Convention, to the early 80s, when we first introduced the Federal Act, that Federal Act had a requirement that the complainant had to establish actual harm or detriment in the course of his or her employment as a condition of raising a successful complaint. I think we've come a long way. But when we also look at the nature of the workplace, we've also come a long way. The nature of the workplace has significantly changed since the early 70s. Most of us are now working hybrid arrangements. Most of us now frequently use social media or technology platforms as an absolute condition on their way in which they work. So you're right. Where there is a complaint, there needs to be some connection with the employment. Yeah. But that doesn't necessarily mean that the harassment occurs using company-issued technology, or occurs during normal working hours, or occurs in the workplace. There's a number of cases which suggest that link is somewhat a low bar to get over, in my view. And even where there is harassment via Facebook, it is quite possibly enough of a connection, given that the persons involved in that interaction are work colleagues. And as such, it may necessarily form workplace sexual harassment, which needs to be investigated. So, really good question. I'd probably suggest that as a starting point, where someone indicates that they have been harassed through the use of social media, don't take the view of precluding consideration of it on the basis that it's happened or occurred outside the workplace. I would strongly encourage you to get advice, and I would strongly be encouraging you to consider dealing with it in a forceful and formal way. Another question is, would welcome my thoughts on settling a sexual harassment complaint in the Human Rights Commission. This sets a dangerous precedent. However, the cost to go to court can also be quite high. Yes, as Annette said, I'm a solicitor, I've been practicing for over 20 years. Sometimes I think that solicitors can be part of the problem rather than the solution. I can't give you a thought on the appropriateness to settle a complaint, given that there's a lot of considerations that you do need to take into account. Yeah. And ultimately, that decision rests with the company based on your cost considerations, but also your risk profile. Yes, you're completely right that settling a complaint at an early stage in the Human Rights Commission may be a more cost-effective approach rather than challenging the matter in court. That's a quite appropriate comment. I don't necessarily think that it sets a dangerous precedent of itself, given that most settlements within the Australian Human Rights Commission would be viewed as a settlement on a no fault basis or a no admission basis. And typically it's reflected within a legal document which contains quite strict confidentiality provisions. So another benefit of reaching a resolution at an early stage is it enables you to control the possible communication or disclosure of that particular circumstance before it goes into the courts, which would obviously be in a very public and open forum. I do think though, and many clients tell me this, that often there is benefit in defending a sexual harassment complaint to ensure that it aligns with your values. So, and where that occurs, there is often a benefit from defending a sexual harassment complaint or any form of legal proceeding, so that you can reinforce those values and communicate that amongst your workforce. But I can't really give you a thought, unfortunately, around the appropriateness of settlement, other than whenever there is a claim, that process of considering the, pros and cons of a settlement and what it means and how that's reflected and who are the parties to that is certainly something that we will support clients through, both HR Assured and FCB Workplace Law, and we have a great deal of experience in doing that. And it's part of a much broader discussion around risk, strategy, etc., which we can take you through at that point in time. Charmaine has raised a question around the definition or view. Is a definition or view of seriously demeaning provided, or will this be defined in precedent? You're right, Charmaine. There's no provision within the Act which provides a view on seriously demeaning. Unfortunately, in my view, I do think that this is something that will play out quite significantly in the courts in the early stages. Whilst the explanatory memorandum sets out a bit around what would be considered seriously demeaning, obviously that's not of legal effect. The courts will take it into consideration, of course, when they view a number of cases, but unfortunately, Charmaine, to your point, it's not in the Act itself, so we're just going to have to see that play out. So that being said, I think that we probably don't have time in the 1 minute left to answer any further questions. I have promised to get people out by 1:30 so you can enjoy a little bit of downtime, get a little bit of lunch before you get back into work. We do sincerely thank you for your attendance. Please look out for invitations on similar topics or other matters throughout the rest of the year and early next year. We do love holding these events. We love speaking to our clients after these events on matters which are relevant to them. So if you do have any questions or need our support in any way to implement the recommendations within this session, please, for HRA clients, please feel free to reach out to our telephone advisory service. For those of you who are not yet HRA clients, please use the QR code and one of my colleagues would be happy to have a complimentary chat with you around your particular requirements. So again, thank you very much for your attendance. Really appreciate it. Enjoy the rest of your week. And if I don't speak to some of you before Christmas, I hope you have a lovely and safe Christmas. Thank you.
Thanks, Wes.